All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Kresnici.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor. Appearing for the SPO this afternoon are Alan Teeger, Ward Fernandez, Sarah Clanton, Marlene Yaha, Leas Magalic Ilic, and my name is Matt Holling.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Kihu, please.
Good afternoon, Your Honor. Gregory Kehoe, Sophie Menegon, and Bonnie Johnson for President Hashim Thaci.
Thank you, Mr. Kihu. Mr. Emerson, please.
Good afternoon, Your Honor. I appear for Mr. Vasili, together with my co-counsel, Mr. Andrew Strong, Ms. Annie O'Reilly, and Mr. Haradin Kuchi.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honor, good afternoon. I appear for Mr. Recep Selimi today with my co-counsel, Mr. Jeffrey Roberts, Mr. Eric Tully, and case manager Natalia Rychenko, and I'm pleased to welcome our new intern, Mr. Christian Farley, who's here today. Thank you.
Thank you, Mr. Young. Ms. Alagendra, please.
Good afternoon, Your Honor. Venkateshwari Alagendra for Mr. Jakub Kresnici. I appear with co-counsels Aidan Ellis and Victor Bayesu, and together with us today are Bento Bichiri and Melissa Gregg, legal associates.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thaci, Veseli, Selimi, and Krasniki are not physically present in the courtroom, but attend this hearing via a video conference. Now I turn to the Counsel for Victims. Mr. Laws, please.
Good afternoon, Your Honor. I'm Simon Laws, appearing for the victims in this case, together with my co-counsel, Maria Radziowska.
Thank you, Mr. Laws. And finally, now I turn to the registry. Mr. Nielsen, please.
Good afternoon, Your Honor. Good afternoon, colleagues. Jonas Nilsson, Head of Judicial Services Division in Registry, representing Registry today.
Thank you, Mr. Nielsen. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 17 October 2022, I scheduled this 15th status conference. I asked the parties to provide with written submissions if they so wished. On 31st October, the SPO and the 4 defense teams submitted their written observations. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, specifically disclosure, translations, defense investigations and next steps, the SPO's first 40 witnesses, and additional defense requests filed in their written submissions. Before I give the floor to the parties to present their views on each item, I confirm that I intend to transfer the case to a trial panel before the end of the year. I intend to rule on the pending requests, but I do not intend to rule on the non-urgent requests that the parties would file between now and the transmission of the case in order not to delay the proceedings. In any case, any pending request at the time of the transfer will be included in the handover document. Let us now move to the first topic, which is disclosure. Given the written submissions of the defense, I will give the floor to the parties on the disclosure of different category of remaining evidentiary material separately. First, the Rule 103 material, which was not on the agenda, but the defense has made submissions on this category of material. Second, the Rule 102.3 material, which was also not in the agenda, but the defense indicated that there are a number of materials it requested prior to 20 May 2022, which have not been disclosed by the SPO. And third, the Rule 107 material, which is protected material for which the consent of the provider is requested. Let us start with exculpatory material. In its written submissions, the defense raised the issue of ongoing late disclosure of exculpatory materials pursuant to Rule 103. The defense notably made reference to 2 additional packages disclosed on 1st and 24 October 2022 that contain a significant number of new exculpatory items. The defense indicated that the vast majority of the materials had been in the SPO's collection for a significant amount of time and, by their own admission, had only recently been reassessed as falling under Rule 103. The Thaci defense and the Vesely defense submit that it is necessary to make a finding of a violation by the SPO of its Rule 103 obligations, and to reimpose a deadline for the SPO to finalize the assessment as exculpatory of any item in the current custody within 1 month. The Krasniqi defense also queried whether a further exculpatory review of the supplemental Rule 1023 notice is ongoing or will be conducted once defense requests are made, as the SPO did in relation to the original Rule 1023 notice. I will first invite the defense to present its views on this point, and then I will give the floor to the SPO. Mr. Kihu, please.
Yes, Your Honor, thank you and good afternoon. Obviously, the 103 disclosures have been late, continuously, notwithstanding Your Honor's admonitions on, I do believe, at least 2 or 3 occasions that you had advised that the SPO should turn this material over immediately and not when they get around to it. Unfortunately, it appears that they have been involved more in the latter than the former and operating immediately. Even as late as October the 24th, the disclosures on the 1st and the 24th, we have 99 out of 113 items that fall into the 103 category. I don't know exactly how we fix this, Judge, except for some type of sanction, because there are any number of items, and we're still not done with it, that continue to be turned over. And unless the issue is pressed by the court, by Your Honor, nothing seems to happen. And we can go through the history of that, but Your Honor is well aware of the history of that, and I don't think we need to take the court's time. There are other issues that the court that should be coming voluntarily from the SPO, but nothing in our files reflects, for instance, the disclosure of information concerning witnesses. For instance, the relocation of witnesses. We know that the SPO has been relocating witnesses. We know that as late as back in December of 2020, Mr. Smith told diplomats that there were 37 relocation requests that had been made. How many more have been made? What other incentives have been given to witnesses to testify? Now, as an analogy to this, those of us who were in the cases in the ICC involving the Kenya individuals, we saw dramatic changes in testimony between statements that were taken before and after they were relocated. Dramatically different. So these are all 103 matters that go to the prosecutor's case. And we again searched this morning, and I discussed this with my colleagues this morning, and we have received no information on relocation requests or other incentives given to witnesses. That is a problem, because we know it has been going on, and the court shouldn't have to order the SPO to turn that information over. That information should be turned over. They haven't even acknowledged they were doing it. The only acknowledgement we have is that Mr. Smith made a public statement or a statement to diplomats back in December of 2020. The other issue that comes up, and suffice it to say, Your Honor knows the back history on what we've done. This is a relatively new issue.
Your Honor, we are now back in public session.
Thank you, Madam Court Officer. Mr. Emerson, please.
Your Honour, in the light of the matters that have been discussed in closed session, may I indicate formally on the record that I'm making the following applications. Of course, they will be followed, where appropriate, with written applications. The first, it can be dealt with as an oral order, I think, which is that Your Honour can, or should rather, adjourn further consideration of the Rule 103 material relating to Serbian intelligence fabrication until you have received full briefings both from the defence and the prosecution explaining what on the face of it are an inexplicable course of events in relation to the matters raised in private session. That will obviously encompass Serbian intelligence. We will amend it for reasons I've touched on to encompass Russian intelligence as well. Secondly, we will ask for an order that Your Honour review provisional release decisions in all cases, certainly in Mr. Vasili's case, in the light of certain evidence referred to in closed session, not yes, those are the but the reason I'm raising it in this way at this stage is because it affects not just the 103 issue, but a number of other issues which we had planned to raise as additional matters at the end of the case. But obviously it will require an oral order, or at least it can certainly be dealt with by way of an oral order to suspend the continuation of the 103 analysis until these pleadings have been exchanged, as well as a procedure for a review of a provisional release, which is due next week, which you cannot conduct until the prosecution has given you the identities of all of the witnesses that emanate from the tainted source, Emiri. So those are the issues why it needs to be dealt with in the course of the orders made arising out of this session.
Thank you, Mr. Emerson. Just regarding your request to postpone the detention review, I would need a very short filing from yourself with a waiver from your client, because the law mandates a review every 2 months, and I will only postpone my review if there is a written agreement of your client. So just formally, I need a short filing with a waiver by your client.
Yes, I mean, we're clearly not waiving it for 2 months, waiving it until Your Honour has had disclosure from the prosecution
Absolutely. I mean, 2 months, I meant every 2 months.
No, I know.
Not for 2 months.
Yes,
but
exactly.
I need the waiver with the specific timing
Yes.
For the proceedings to be on the record.
Thank you.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, Your Honour, very briefly, in relation to the point that Your Honour made about 103 and the fact that some of the co-accused had made an application or submission for a finding of violation of 103 material, we respectfully support that. And, Your Honour, the reality is this. It's important that violations, breaches of 103 are formally recognised with respect by the court. It's important that there's a judicial recognition of these violations, especially, for example, to counter the argument that we get from time to time by those across the court, which is that their conduct is one of due diligence and their conduct is diligent. And the reality is the indictment, as it were, in terms of allegations of breaches of 103 is piling up. There are already references, not just orally today, but in the submissions that were made to Your Honour for this very hearing. So we do say the court cannot, with respect, remain silent. The court has to make a judicial decision to mark these violations, which are very serious, because, as you know, of all the disclosure provisions, Rule 103 is probably the most important to the defence because it goes to the guilt or innocence of an accused. It's exculpatory. And so for these reasons, we do ask Your Honour to formally make findings, and we do support what Mr Emerson says, submits that these issues may well go to what we suggest should be the case, in other words, a review of provisional release provisions, because it goes to the diligence of the prosecution. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Thank you, Your Honour. We support the submissions that have been made seeking a finding of breach of disclosure obligations for the reasons in the written filings. We also very strongly support the applications made orally today for full disclosure of all matters that were addressed in closed session earlier. It's such a serious matter that nothing less than full disclosure at this point could possibly suffice.
Thank you, Mr. Ellis. Ms. O'Reilly, please.
I'll be very quick, Your Honour. I just wanted to go back to this general issue of the disclosure batches that came late, the ones that were referenced in our submissions and those of the Thacis. That contained various materials, including mainly interviews that the SBO had carried out with international witnesses, so 2 OSCE witnesses, a K4 witness and one of their own witnesses. And I'm highlighting that because we'd previously pointed out the difference between those interviews in which the SBO was there, were aware of the 103 information as it was coming out, as opposed to 103 information emanating, for instance, from EULEX proceedings. There is a great deal of the former type of information in those two batches. Now, you recall at the last status conference, I mentioned that in September 2021, the SBO had said they were reviewing the 1023 index to make sure that they had removed all the 103 material from that and disclosed it to us. Now, the vast majority of items that were the subject of their most recent request for protective measures for 103, I realise this is a little bit complicated, but say 121 items of the 136 items in F1055, those were from the 1023 index. So what we are continuing to see is obvious Rule 103 information generated from interviews that the SBO carried out that should have been disclosed long ago, but just remained on the 1023 index. Now, you'll also recall that there is a small amount of information that none of us have requested from the 1023 index. Not very much, it has to be said, but there is some information there that has not been requested and therefore we have reason to believe has not been reviewed for 103 information. Given how many 103 documents have come off that 1023 list, I would simply ask you to order the SBO to review all items that we have not requested and disclose any 103 items to us. Thank you, Your Honour.
Thank you, Mr. Reilly. Mr. Prosecutor, on the different points that have been raised by the defense team, especially this last point about the Rule 1023 material that has not been requested by the defense and the request to get an extra review of this material. You have the floor.
Your Honor, first of all, and I think it's clear from our disclosure procedure as to the last request, we have already reviewed this material for Rule 103. There is very little material left on the original relevance list that hasn't also been re-reviewed in the context of the Rule 1023 review. We are not going to just start blindly reviewing items in order to see if there's Rule 103 content. If we get specific items selected from the list, following our normal procedure, we will re-review them. But we don't see any reason why we need to revisit this group of items that the defense didn't even seem to want off of the descriptions as a judicially ordered thing. On the broader issue that has been presented in the hearing today, in the SPO's submission, this is another attempt by the defense to hijack the agenda of this court and to make this about something other than what it is. We had a Dan Everts discussion in one of these hearings, and it had a lot of similar characteristics to it, and it ended up in a place where it was wildly overstated what the defense was saying. This is going to end in that same place, and we need to see the application of the defense to understand exactly what pieces of it they want. And I'll leave it at that for now, and we'll respond when that application is filed.
Thank you, Mr. Prosecutor. Mr. Q, very briefly,
Your Honor,
we have many other points in our agenda today, and it's already
very
1 hour from the
briefly,
beginning.
Your Honor. I just have to comment on that specious argument that was just made by counsel about they're not supposed to go through these documents to determine if there's 103 material. Yes, they are. The rule is very specific. Your Honor's rules have been very specific. If the information affects the credibility or reliability of the prosecutor's evidence, that is 103 material. So counsel's recitation of the law as to what their requirements are clearly highlights the problem within the SPO and the review of these documents. They should be reminded to look back at 103 as to what their obligation is. And yes, they are supposed to go back through evidence and items and information in their possession on their own without Your Honor's order or prompting and disclose Rule 103 material immediately, as Your Honor has noted on numerous occasions. Thank you.
I don't want to try Your Honour's patience at all, but I just want to comment on the second part of that response, which is the suggestion that the prosecution don't know what it is they're being asked to give information about. That is a misleading statement. We have just come out of private session in which I pointedly gave the opportunity to the prosecution, including Mr. Tiga, 3 times the opportunity to give the factual explanation that they already know, and they have every time chosen to try to avoid the question with specious arguments of various different kinds. It's completely wrong to come out into open session and pretend something different happened.
Thank you, Mr. Emerson. We will now move to the next item within the disclosure item of the agenda, which is the Rule 1023 material. And again, it wasn't in the initial agenda, but it's been raised by the defense in its written submissions, hence the discussion about this today. In its written submissions, the Thaci defense indicated that there are a number of materials it requested prior to 20 May 2022, which have not been disclosed by the SPO. The Vesely defense also indicated that it appears that there may be as many as 2,000 items yet to be disclosed. According to the Krasniqi defense, the SPO failed to disclose as many as 1,162 items to the defense before the deadline of 30 September. The defense also indicated that the way in which disclosure has been conducted make it extremely cumbersome for the defense to review them. As a result, the Krasniqi defense indicated that it is not currently able to confirm that the SPO has disclosed challenged materiality or sought protective measures in relation to all requests from the original Rule 1023 notice. I invite the defense to indicate if it has raised this inter partes with the SPO and what document it concerns. The Selimi defense also indicated that it has requested disclosure of all 8,711 items from the SPO's Supplementary Rule 1023 list and requested that I set a deadline for disclosure of these documents. The Krasniqi defense also proposes a calendar related to the Supplementary Rule 1023 notice. It proposes an initial deadline of 4 December 2022 for defense requests for material from the Supplemental Rule 1023 notice, with the SPO to provide disclosure, request protective measures, and or challenge materiality by 4 January 2023. I invite the parties to provide submissions on the latest disclosure of Rule 1023 material that was requested after 20 May and therefore not subject to the 30 September deadline, and on the proposed calendar proposal for the material from the SPO Supplementary Rule 1023 list. And we will start with the defense. Mr. Kihu, please.
Suffice it to say, Your Honor, that this is another issue that has been extant and going on for any number of our conferences with Your Honor, and it still has not been satisfactorily complied with by the SBO. And part of that reason is the fashion in which the information is being disclosed. We ask for information as they disclose it. We ask for additional information, and for some reason that is inexplicable to me and to the staff, I might say, that the information comes back with new item numbers, new ERN numbers, items being split into multiple parts. The disclosure on this score is very confusing, to say the least. We made a request for 6,000 items, as Your Honor knows, and we do believe we've gotten approximately 3,000. And we are attempting diligently, and I can attest that the colleagues that are in the office today have been attempting to find out exactly what they have, what the SBO has complied with and what they have not complied with, and that is not easy. Today, when we were talking about this morning, my colleague, Ms. Menegon, sent an email to, or Ms. Johnson sent an email to the SBO asking for an additional information on the score. We're just trying to get the information. We're not trying to get into a long, protracted argument about it. We just want the information. Obviously, their most recent disclosure, Your Honor, wanted to know exactly where we were with the supplemental 103 disclosure that was made by the SPO, and we have requested an additional 6,000 items from that. So suffice it to say, and I'm sure that this is a common refrain that you will get from our co-accused in this matter, that keeping track of exactly what we're getting and how we're getting it and in what form is difficult, and certainly there has been, as Your Honor knows from this many, many times it being brought up, Your Honor knows that there are delays that are been extraordinary over the months that we've been talking about this. Thank you.
Thank you, Mr. Kihu. Ms. O'Reilly, please.
Your Honour, as regards inter partes discussions, we have been in contact with the SBO about these 2,000 items that we can't track down. Yesterday, after we sent them a reminder, we were able to get some corrected information. So that number has come down to 790 items that we can't locate right now. We're still waiting on further corrected information from them. Once we have that, we're hopeful that it will come down further. As regards the most recent 1023 notice, like the Selimi defence, we've also requested everything. I think we can all agree that the 1023 process that we followed last time wasn't great, and this seems to be a more efficient way of managing the process. So we've requested everything, and given that it's a much smaller amount than the original batch, it seems reasonable that they could disclose it by 5 to 6 weeks from now. But of course, we'll have to hear submissions from the SBO and what's feasible. Thank you, Your Honour.
Thank you, Ms. O'Reilly. Mr. Young, please.
Yes, very briefly. Your you want to correctly summarise the situation that we asked for a deadline in relation to these materials from the 1023 supplementary list. And the reason we ask, or to add a bit of context, simply because, and I'm sure this is what Your Honour intends, we want to have these matters fully resolved before any transfer to the trial panel. Thank you.
Thank you, Mr. Young. Mr. Ellis, please. And just before you take the floor, I note that all the other defense teams have made their request for the 1023 supplemental notice. So, because in your submissions you ask for some time for your defense team to request these documents, if you can indicate how much time you need, because all the defense teams already have made their request regarding this supplementary notice. Sorry to interrupt.
Let me tackle that straight away, Your Honour. The position as we see it is we've received this supplemental notice with, I think, 8,700 odd items on it. And what we want, in common, I think, with all defence teams, is to find a procedure to manage that, ideally, as much as possible before this gets to the trial panel, so that the new trial panel are not immediately greeted with what could be hundreds of protective measure requests or materiality challenges. There are two ways to do that, Your Honour. One is that we could simply ask for everything on the list. I know that's what some of our colleagues have done. We appreciate that that approach did not find favour with the court at the 8th status conference almost a year ago in relation to the original 1023 notice. The supplemental notice is of course much shorter at 8,700 items. We've also had the experience of a year's proceedings pre-trial going through the original 1023 notice, and that was certainly a large part of the delay that we've all experienced. So we would join a request for everything on the list if the court is content to proceed in that way, everything on the supplemental list if the court is content to proceed in that way. If not, Your Honour, we would need to review the list item by item and make our requests. We have in fact started that process and we've made good progress. I asked for a month in the written submissions. I don't think we would need that long to go item by item, but it's still 8,000 items, Your Honour. It would still take some time. Given the size of the list, we envisage making one substantial request rather than doing it on a rolling basis. We can do that for 8,000 items. We couldn't for 69,000 items. And so that's why, Your Honour, we would seek deadlines today so that we can manage what remains of this pre-trial process. In relation to the original notice, Your Honour, we are still working through comparing the spreadsheets of what we've received with what we requested. If we identify issues, we will raise them inter partes, Your Honour.
Thank you, Mr. Ellis. Mr. Prosecutor, please. Unless, Mr. Keogh, you want to supplement your initial submissions?
My apologies, Judge, one supplement. We, of course, support the application for a deadline as well. Thank you.
Thank you, Mr. Keogh. Mr. Prosecutor, please.
Yes, the way I understand it, Your Honor, there's three parts that we're going to respond to. The first part is actually quite straightforward. The items that were requested off the original Rule 1023 notice that are not covered by the 20 May deadline are going to be disclosed in the next 2 weeks. They're in an advanced stage of processing. So the other two items would then be the items that are alleged to be missing from the 30 September deadline, and then the updated Rule 1023 notice. For the first point, we did a thorough check of all Rule 1023 requests to confirm our compliance with the 30 September deadline. The results of that check are reflected in our 13 October 2022 notification. If the defense considers that there are outstanding items, they have to first compare the missing items against the Excels that we sent on their request, setting out how each item in each Rule 1023 request was resolved. Once this is done, we would say that the next step should be for the defense to come to us inter partes with any outstanding questions they have about allegedly missing items so that we can look into the discrepancy. The submissions made today overstate how much inter partes correspondence there has been on this. We've received very limited information from the defense to date, Before today, we had only gotten information about 8 specific ERNs identified by all the 4 defense teams. There are 6 identified by the Krasniqi defense in their written status conference submissions, and I'm glad that it had a bigger effect than just the 2 items that they mentioned, but the Vesely defense only gave 2 ERNs in their email to us that they were referencing earlier. We've checked these 8. Of the 8, 3 of them had their resolution clearly provided in the Excels. 3 of them aren't disclosed under Rule 1023 because they were actually disclosed under other rules, such that just typing the ERN into legal workflow would have resolved the question. And the other 2 are actually typos. One in an ERN, it was a typo on our part, but we disclosed the corrected one in time. The other was a typo in one of the Excels, and it was an item that was also correctly disclosed in time. The Thaci defense mentioned they sent another email. They sent that just over an hour before the status conference. It had 16 items in an Excel. We've had time to check all of them. All 16 have their resolution clearly in the Excels provided to the defense on 14 October. We appreciate that the Vesely defense sent another email to us. They sent it very shortly before the status conference, and we need to evaluate that. But we would ask that this be done for these items before any action is necessary to be taken by Your Honor. As for the updated Rule 1023 notice, this was filed on 7 October 2022. No defense team selected any items off of that notice until Monday, the day that their written status conference submissions were due. And then the Salimi defense indeed asked for every single item off the notice. The Vesely defense has done the same since. There's been a request from the Thaci defense as well. At this point, the SPO considers that there's really no reason for differentiating anymore between the defense teams when there are already 2 teams that have requested every item off the updated notice. The SPO is simply just going to review and process these items for all the defense teams. So there's no selection date necessary in our submission. As for a disclosure protective measures deadline, the SPO is already working on the first disclosures following the selection of items from the defense this week. We expect to disclose thousands of items in the next few weeks, and will continue to do so on a rolling basis. It's unreasonable for the defense to wait nearly a month to select any items and then to seek to impose a deadline on the SPO that would necessitate its staff working through the winter recess to meet. We're expecting to be in a position to finish the disclosures off this list by 31 January, regardless of whether any deadline is set. So given the envisaged timing of when the case record is to be transferred, it is suggested that the trial panel be the one to decide whether there needs to be a deadline for disclosure of items off this notice. Thank you.
Thank you, Mr. Halling. Mr. Kihu, please, briefly.
I smiled, Judge, because counsel just said that they'll be finished disclosing this on 31 January. Correct me if I'm wrong, Judge, but didn't they say that they were going to be ready for trial in January? I think that in their disclosure, they said they didn't object to the transfer of the panel and they will be ready for trial in January. And now we're talking about having a disclosure on the 31st of January. I mean, please. I mean, we can't make those arguments. You can't come in here and tell Your Honor that they've complied with everything to the T every time they came down the line. You had a September 30th deadline that Your Honor gave them, which how many times did that change? They filed they filed a pleading on the 3rd saying, oh, we fulfilled all our obligations. And then they filed another one on the 13th. Ah, well, you know, we really didn't. We made a mistake, and we have some more stuff that should have been filed in. So please. I mean, this whole attitude that they have been complying with the 1023 obligations to a T throughout all of this is just not accurate. And I think Your Honor is fully aware of that. You know, we're in favor of a deadline. Why? Because our clients want to get to trial. I know the court wants to get this to the trial. If we wait for heaven knows how long to get this trial will continue to be kicked back, which is in nobody's interest. So you can't come in and say, I'm ready for trial in January, and then say our 1023 disclosures are going to be done the 31st of January, which is essentially the 1st of February. I'm not the brightest person in the world, but those dates simply don't work, which is why I think all of my colleagues have asked for a date by which these disclosures need to be made.
Thank you, Mr. Kihu. I don't see any... No, Mr. Ellis, please.
Your Honour, very briefly, the reason we put the 4th of January was because that was 1 month from the deadline we were suggesting for defence requests. Had we asked for 3 weeks, it would have been an even more unfortunate date. But to ask for the 31st of January, when what we're talking about is 8,700 documents, in our submission, 3 months to disclose that number of items. At its peak over the summer, the submission was that 5,000 were being processed in a week. We would say it doesn't need to be pushed all the way to the 31st of January.
Thank you, Mr. Ellis. Mr. Prosecutor, the problem with the 31st of January deadline is that if you file any request for protective measures, the items will not be disclosed before March, the time for the parties to provide submissions and the time for the panel to rule on your request. Is there any possibility that the deadline can be set before 31st of January, or at least the deadline for the SPO to request protective measures or submit materiality challenges?
So if I understand Your Honour's question, the question could be if the protective measures deadline for the items could be set slightly before the 31st of January. I mean, the more slightly before, the better, but we could be able to accommodate that.
Thank you, Mr. Alling. This is noted. We'll now move to the third category of evidentiary material to be discussed today, which is the Rule 107 material. In its written submissions, the SPO indicated that it continues to engage with Rule 107 information providers concerning pending clearances, that the provider with the overwhelming majority of outstanding items indicated that the SPO last week cleared the majority of items, totaling 821 pages, and that once these items are received, there should be less than 50 items pending clearance, among which less than 25 contain exculpatory material. The SPO also indicated that it anticipates filing 2 Rule 107 applications by mid-November 2022, and that further clearance decisions may prompt the need for further applications. In its written submission, the Krasniqi defense reiterated its request for an order imposing a deadline for the SPO to complete its Rule 107 disclosure, which should be resolved prior to the transfer of the case to a trial panel. I invite the SPO first to give clarification in its oral submissions and the defense to present their views if they wish. Mr. Halling, please.
Yes, Your Honour, in relation to the various points just mentioned. As for the items that were recently cleared, we received them on November 1st. So we have them, we're reviewing the materials that are cleared now. In terms of whether...
Sorry, and in terms of numbers, it correspond to what you indicated in your written submissions?
It does.
Thank you.
In terms of the prospect about setting a deadline for Rule 107 clearances, I mean, the evolution of the Rule 107 clearances, like as the condition set in our submission has been fulfilled, there's less than 50 uncleared items yet. The progress shows that no deadline is, strictly speaking, required. The SPO maintains that it will continue the Rule 107 negotiations and, subject to further direction of the trial panel, file further applications as needed.
Thank you, Mr. Halling. Does any of the defense team want to make oral submissions? Mr. Kihu.
Yes, Your Honor. Your Honor said that they were, I'm not sure exactly what you noted was pending clearance, but I'm just looking at the SPO's filing in paragraph 3 that notes that there are 200 items that are still pending clearance, in addition to whatever has been cleared before that we're awaiting disclosure on. And in that, of course, there are 50 items, additional items will remain after, once the above provider completes its clearances, and then 25 of approximately, less than 25, I guess it's the quote, of these items contain Rule 103 material. Again, we're in the dark about the 107 material, as is normal in this instance, but we would like some idea, number one, of how much information we're talking about. And number two, we are certainly most interested in this 103 material, even if it's less than 25 items. I mean, is this 25 pages, is 25 documents? That I ask Your Honor to prioritize, going back to 103, that we should be dealt with immediately, because that's the information. We want to see all the information, but obviously the 103 information is paramount. Thank you.
Thank you, Mr. Kihu. Ms. O'Reilly, please.
Your Honour, the submission that no deadline is required is surely not a supportable one. I mean, is it suggested that we're going to go to trial and this matter still hasn't been resolved? We do need a deadline. We need a deadline that's sufficiently in advance of trial for us to either have the material or have counterbalancing items that go to the same substance of that material. You know, it's very unclear what's going on here. We've had so little disclosure as to who these providers are, what the nature of this material is. Of course, none of us can have any trust in this submission that only 25 or less than 25 have exculpatory information in them. We need to know more, and we need to know it as soon as possible. Thank you, Your Honour.
Thank you, Ms. O'Reilly. Mr. Young?
Nothing to add, save that we support a deadline. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, when pre-trial proceedings have been going on for 2 years, the fact that progress has been made recently is not a good reason not to impose a deadline. Again, we seek to resolve this during this pre-trial phase and not to leave issues that could be resolved now hanging over for the trial panel.
Thank you, Mr. Ellis. This is noted. Mr. Helling, do you want to add anything?
Just briefly, Your Honor, because the Thaci defense has, for the second agenda item point in a row, misread our written submissions. We had recently gotten clearance as of the day of our written submissions, but we hadn't received the materials yet. So they were less than around 200 items, but now we've gotten the items, and so that's why the number drops to where it is now. In terms of the number of items that are Rule 103, we're hoping that the number is even less than the 25 we had in our written submissions on Monday, but the exact number depends on how the recently cleared pages were redacted. So, I mean, a simple example, a cleared Rule 107 item that has Rule 103 content redacted in it isn't really cleared for Rule 103 disclosure, and we may have to go back. And so we're evaluating the new pages that we've received just now, but as to the question about, you know, the SPO keeps making promises in this regard. We have made consistent progress on the Rule 107 items clearances throughout these pretrial proceedings, and we've now gotten down to a number that's well under 100, and we would ask that this process could continue and that it will naturally end in the place everyone wants, which is to have clear decisions and disclosures made with no need for further litigation.
Thank you, Mr. Helling.
Just one last thing, Your Honor.
Very briefly, please.
Very briefly, with all due respect to counsel, I am reading what he filed in paragraph 3. While at paragraph 3 on page 1 that he filed Monday, while as of this filing there are still approximately 200 items relevant to this case pending clearance. I didn't make this up. That's what he wrote. Once the items that are above are received, that number is anticipated to be less than 50. That's what he wrote. We are just trying to get a handle on exactly what is coming. We're trying to get a handle on the 103 material. And again, Judge, without going in and trying to find fault, we just want the information on today or soon, as opposed to 2 months down, 3 months down the line. It's as simple as that. It's similar to the application on the 103 material. We just want the information as soon as possible.
Thank you, Mr. Kihu. Before we go for a break, let us move to the next item in our agenda, which should be short, which is translations. I note that the parties did not mention any translation issues in their written submissions. I invite the registry to provide an update on outstanding translations, in particular, if needed, on the progress of the translation of the further amended indictment and the Rule 109C chart and its supplement. Mr. Nielsen.
Thank you, Your Honor. With regard to the Rule 109C chart, you will recall that in March, the defense for Mr. Krasniqi had requested translation of parts of that chart as a matter of priority. These translations were delivered in batches in April, May, and then finally in July. There have not been any further requests in relation to this or in relation to the revised chart. With regard to the further amended indictment, I can report that the Albanian translation has been finalized and it's in the process of being served formally on the accused. And beyond this, there are no other outstanding prioritized requests for translation. Thank you.
Thank you, Mr. Nielsen. Does anybody wants to take the floor on this topic? I don't see any request for the floor. I see that it's nearly an hour and a half since we started, so before starting the next item in our agenda, which is defense investigations, we will have a break. We will reconvene in 20 minutes at 3:20. The hearing is adjourned.
All rise. All rise. Please be seated.
Let us now move to the defense investigations and next steps. Firstly, I note that the Kosovar authorities have appointed a focal point as requested by the defense. I thank the registry for its efforts on this matter. In their written submissions, the defense indicated that their investigations are continuing and are likely to continue after the transmission of the case to a trial panel. On 21 October 2022, the 4 defense teams filed their pretrial brief according to the timeline I set. I also take note that the Thaci requests for unique investigative opportunity and the written decisions will be issued before the transmission of the case to the trial panel on this matter. I also take note of the Thaci defense, Vesili defense, and Selimi defense filings regarding notice of an alibi or grounds excluding responsibility. I thank the defense for their submissions on all these matters. Regarding points of agreement on law and facts, the SPO indicated that it is currently reviewing a joint defense proposal for agreed facts to assess whether pursuing additional agreements of facts or law would be worthwhile. The Thaci defense indicated that it has agreed to 18 facts with the SPO and that at a minimum it can file a notice setting out the 18 facts that have previously been agreed with the SPO. The Selimi defense indicated that it has not agreed to any further facts proposed by the SPO since the 14th status conference and considers discussions on this to have come to an end. It also indicated that no discussions on the law are ongoing between the parties. In any case, the SPO and the Thaci, Vesili, and Selimi defense teams indicated that an agreed facts notice can be filed by 18 November 2022. I invite the parties to give detail on their inter partes discussions on this matter if they wish. I also note that the 4 defense teams do not currently foresee any difficulty in filing a notice of objections to the admissibility of evidentiary material pursuant to Rule 95 by 18 November 2022. However, the 4 defense teams further indicated that they will not focus on particular items but on categories of evidence which may be the object of specific challenges. The Veseli, Selimi, and Krasniqi defense teams further noted that their submissions on admissibility will necessarily be preliminary in nature. I will now give the floor to the parties on all these issues related to defense investigations, starting with the defense. Mr. Kihu, please.
Yes, Your Honor. Would you like to go through the series of them or take them one at a time?
The series of them, not one at a time, not like the previous time,
That's
because
fine.
I think most of the what we discussed last time has already been discussed before, or it's moot because the timeline has passed. So.
Understood. Understood. Just seeking some instruction as to how you want these addressed. Obviously, Your Honor, we continue to get additions to the SPO's witness list and witnesses. We've gotten another 4 witnesses and another 147 additional exhibits on that score. Some of those witnesses even are talking about issues that are outside of the scope of the indictment. This, of course, presents additional challenges to the defense teams to investigate these matters, which I'm sure Your Honor appreciates. We have 66 paragraphs, a significant number of paragraphs in the indictment that have been redacted. There has been some statement by the SPO on the 28th of October to say that 54 will be unredacted 30 days prior to trial and 12 30 days prior to the testimony. Your Honor, I would ask that that be revisited in the sense of there's no reason why at this juncture of this case all of these paragraphs in the indictments need to be redacted. This is significantly hampering any number of issues, not the least of which is a document, an item that you and I, Your Honor, have become quite familiar with, notices of alibi. and the ability or inability to do that. Obviously, you've seen in our pretrial brief that, consistent with my prior comments to Your Honor, that I tried to lay out where my client was, President Thaci, during operative time frames. That's not your traditional alibi, because I don't know when the allegations say in the indictment say certain events took place. That's how I was hampered. But in good faith, I tried to give an idea, as I said to Your Honor previously, an idea of where my client was internationally through all the operative time frames of this indictment. Obviously, you know, we continue to talk about the disclosures and what we're going to get at the 11th hour. I mean, obviously, there are 98 confidential witnesses, 68 that we're going to hear about 30 days prior to trial, another 23 30 days prior to their testimony, and 46,000 pages of information. Obviously, it's going to be a daunting task for us to get all of this done efficiently and completely prior to trial. That has obviously, and I don't want to re-argue this issue, Judge, obviously has been significantly hampered by the witness protocol and our ability or inability to talk to various witnesses. On that score, I think you saw in our filing the request to remove the protocol for one of the witnesses that is on the SPO's list. He is going to be on our list. I'm gladly give you the number on the record, but it is in fact in our filing. We are going to ask for that because he is another individual, an elderly gentleman, who is part of our deposition submission to Your Honor. Progress on facts and law, obviously, that as Your Honor reiterated, we have 18 facts that we have agreed to. We have given 135 facts to the SPO. I believe that was transmitted on Monday by the teams concerning crimes by the Serbs in 1998 and 1999. With regard to the filing any notices concerning objections, we will obviously file objections, but they will be broad objections without going into the specifics. Why? Because of the witnesses that are involved and, of course, in the progeny of a lot of the information coming from the SPO, to the extent that it comes from Serb intelligence sources or other organs of the Serb state. We are certainly not going to stipulate to anything in that regard. So that presents some difficulties without some disclosure coming from the SPO. But we will make our appropriate filing on the 8th per Your Honor's instructions, and we'll explain exactly where we are on that score. I think that covers everything that Your Honor outlined. If I missed something, please let me know.
Thank you, Mr. Kihu. Mr. Emerson, please.
With nothing to add to our written submissions.
Thank you, Mr. Emerson. Mr. Young, please.
Again, nothing to add to our written submissions. Thank you.
Thank you, Mr. Young. Ms. Lagendra?
We have nothing to add, Your Honor.
Thank you, Mr. Lagendra. Mr. Prosecutor, do you want to respond to the defense submissions, whether they are written submissions or the oral submissions of Mr. Kihu, please?
Certainly, be brief. As to the point about agreed facts, as the SPO has mentioned, the SPO will evaluate those proposed facts and respond in time to file notices by 18 November. Even now, it can be said that these proposed agreements aren't going to expedite this trial. Every single fact proposed relates to alleged crimes committed by Serbian forces, none of which are charged in this case. As for most of the other submissions from Mr. Keogh, the redactions to the indictment have been explained, and there's a timeline for their lifting, and this is filing 1064 Annex 2. As has been discussed many times, these redactions are in place to preserve protective measures decisions. And the defense team can say that it's daunting for them, but it's something that they have to do. These are necessary protective measures, and unless there's a variance, the trial has already been thought through that it can still be fair and that they can still be sufficiently prepared. And so we will follow all directions to the letter in terms of lifting these redactions, but the timeline is clear and the consequences of what it means after they're lifted is clear.
Thank you, Mr. Halling. Mr. Kihu,
If I may
please.
respond to that, Judge, we are well aware of our obligations. We have been following Your Honor's orders to a T. throughout all of this. There have never been any indication of any threats to any witnesses whatsoever by my client or any of the other accused. We understand our obligations, and we understand Your Honor's orders, and we are abiding by Your Honors and respect those orders as officers of the court. That being said, this trial is supposed to be on an even basis, on a level playing field, and the fact of the matter is that with all of the information that the SPO continues to pile on with, non-disclosures, redactions, etc., the failure to disclose 103 material in a timely fashion, that level playing field has changed. And we have to be cognizant of that. We will proceed based on the court's orders as we have been doing. But to have a full breadth of exactly what this case is at this point, with all of the information that we haven't had disclosed, is not only daunting, it is virtually impossible. As one of my colleagues noted the last hearings, 46,000 pages of information, which you know is important information, 30 days before trial. We'll have to get through it somehow, some way. But to say that that is not a daunting proposition, or any such non-disclosure immediately before trial has happened in any other tribunal is just not accurate, because it hasn't.
Thank you, Mr. Kihu. Mr. Halling, very briefly, please.
Yes, just when Mr. Keogh mentioned proceeding on the court's orders as we are doing, I was reminded that there was one aspect of their submissions I didn't address. It was this request in relation to the contact protocol and the witness that they mentioned. The Thaci defense, despite what they just said, and incidentally, as with all defense teams in this case, has never actually sought to contact a witness in accordance with the contact protocol ordered in this case. And the Thaci defense failed to substantiate then or in their written submissions what prejudice is caused by working within a court-ordered procedure they have never attempted to follow even once. This is another attempt to challenge or reconsider the protocol. If the defense wants to contact the witness they mentioned, they should act in conformity with the court-ordered procedure.
Let me respond to
Mr.
that,
Halling.
Judge. The protocol
Kihu, please.
requires us to have interviews with the SPO present. Never in the history of the cases that I have been involved in where I've conducted investigations did I bring the other side into an interview to ask questions. We've outlined all of these issues that we find troubling with the protocol. Your Honor is well aware of that. Those issues remain extant. Those issues are very significant issues that impact on the attorney-client privilege, the work product privilege, and how we are going to conduct this investigation. Now, with regard to talking to witnesses, with that protocol, we are hampered to conduct our investigation under those circumstances. If the SPO thinks that is the way it has to be, or they don't think we can operate it any other way, I beg to differ. The first way they can show their good faith in this is to walk away from the protocol as it pertains to the witness that we have laid out. Now, I will tell you that this is a witness that is going to be a defense witness. And as a consequence, the SPO cannot contact him either. They are not permitted to make any contact with him at all because they are being informed he is a defense witness. So we can bypass all of these issues, lift the protocol with regard to this international professional witness, and essentially assist this case and move it along.
Okay,
Your Honor.
this will be decided by written ruling. I don't see any requests for the floor, so we'll move to the next topic in our agenda, which is the SPO witness list. In its written submissions, the SPO indicated that it intends to provide a provisional list of its first 40 witnesses by 18 November 2022, as ordered in the last status conference. Regarding the Rule 153, 154, and 155 statements, the SPO indicated that it intends to file its first motion seeking to admit evidence under these rules before the commencement of the trial. I invite the SPO to make any additional oral submissions on this matter. Mr. Halling.
Your Honor, our written submissions covered all of these points. Unless the court has specific questions, we had nothing further.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, with regard to these witnesses, obviously some of these witnesses, and I am talking about the 153, 154, 155 witnesses, that information is voluminous. At least one of these witnesses, and I believe it's I know it's a 154 witness that they have, it's literally 12 binders of information. And what we need to know is what item in that witness statement are they going to put in under 154 upon which they will rely. They can't be talking to the court and saying, here are 12 binders of information. If they are, we'll be reading this information from now until 2025. So we ask Judge for some restrictions and to tell us exactly what they're going to put in, and don't leave this to the eve of trial.
Thank you, Mr. Kihu.
Yes, Your Honour, very
Miss-
briefly,
just-
can I address you on that?
Mr. Emerson, do you want to
sorry.
take the floor on this? No? Thank you, Mr. Emerson. Mr. Young, please.
Yes, simply just to reinforce the points made by Mr. Kehoe, Your Honour may not recall, but in the July status conference hearing, I think it was Mr. Roberts who was making submissions, but in our written submissions, we made it quite clear that the prosecution should be able to identify and disclose the documents that they will rely upon at trial. Obviously save a lot of time, effort, and it would be a very important case management decision if Your Honour takes the view, and there should be an order that they state in terms what documents they're going to rely upon, given that there are so many thousands, tens of thousands of documents. So far, I don't believe we've had any response at all to our, with respect, sensible request.
Thank you, Mr. Young. Ms. Salagendra or Mr. Bayezou?
Just not much to add, just to agree and to endorse the position taken by the Thaci defense and the Salimi defense. It's a sea of information which includes the multiple witness statements based on these three rules, and early understanding by the defense of the scope and of the magnitude of its motions will help indeed the defense to prepare for this forthcoming motions, and it's a matter of good case management practice to have this information in advance.
Thank you, Mr. Bayezou. Mr. Emerson, please.
I apologise. I waived my right to make a submission too quickly. We have raised in our submissions for today, under other matters 4B, the issue of statements under 153, 154 and 155 in relation to witnesses who've got multiple sources of evidence within the material. And obviously, there are witnesses for whom there are multiple, up to 6, 7 apparently conflicting documents, which, if they're going to be tendered, have to be coherent. Otherwise, the defence and the trial chamber, and presumably in response to the prosecution, are going to be deciding at some later stage what version of events they're choosing to rely upon. And that's not a basis for any sound trial management, but above all, it can't possibly serve the interests of justice. So what we're going to invite Your Honour to order is that for any witness under Rule 153, tendered under Rule 153, 154 or 155, the prosecution prepare a summary statement of the evidence it proposes to tender from that witness, with all of the existing materials in front of the trial chamber by way of issue of material capable of testing the witness's credibility. Now, obviously, you can't get the signature from a witness that's dead or otherwise unable to sign, but the trial chamber does need to know what exactly from that witness's various utterings are relevant. It's very difficult in this case to find a witness who's given more than one version where the versions are consistent as to important detail. I mean, all of these witnesses are replete where they've testified in other cases or where indeed material has been served, which involves multiple interviews, replete with contradictions. And how is the trial chamber to make sense of that material and what is relied upon unless the prosecution pins its colours to the mast? So rather than asking them to say, well, which of these materials do we say we're relying on, because that'll end up with a terrible mess. It really needs that each of these witness statements to be crystallised into an accurate summary from what the witnesses have said, which the prosecution proposes to tender. Now, there may be all sorts of difficulties with that, but at the end of the day, those are difficulties for the prosecution to overcome. And if they can't overcome them, the witness is not admissible. So it's a basic principle with any of these, any witness tendered under any rule in a national or international court where the witness is not available for testimony, that anything that goes to the witness's credibility should be before the trial chamber, both at the time of deciding whether to admit the testimony and at the time, obviously, of deciding what weight to attach to it. So this is not ready. The prosecution is nowhere near ready to be filing applications under those provisions without being able to put forward a coherent statement from the witness that they seek to elicit. We, of course, are entitled to rely on all of the other material to draw to the court's attention, both at the admissibility stage and at the final stage of assessment of the evidence, the various inconsistencies that are apparent on the documents that have been served. But at the moment, what you're looking to what the prosecution is proposing, is, as far as we understand it, is to dump a vast amount of material on the trial chamber and say, there you are, you sort it out. And that is not the way to prosecute a case that's going to be coherent and manageable for the trial chamber. And at the same time, if they are in a position to be making these applications, I can't remember exactly when it was said that they would be being made in the before trial, I think was the time frame, then they must be made together with the evidence that is said to justify their admission under the relevant rule. And it's not just an assertion that they can do it, it has to be backed up by evidence of absence, illness, inability, which is available itself to be properly tested. I mean, each of one of these witnesses will be the subject of vigorous challenge. And as you will have seen from our pre-trial brief, there are witnesses that are relied on by the prosecution in relation to the only instances in the brief where they alleged the presence of Mr. Vasili in some probative way, although we've disputed in our brief for the reasons we've given, that they take the prosecution's case any further. But one thing that is absolutely certain is we've flagged up with those we know about why the trial chamber shouldn't admit those witnesses at all, based on the other testimony they've given in other cases, or other matters that are relevant to their credibility. So all of that needs to be litigated before the trial chamber, before statements are admitted, and will be vigorously contested. So if by saying they'll be ready to dump a load of material on the trial chamber before trial, that is what's being suggested, that is not compliance with the rule. And compliance with the rule requires a single, coherent statement of what the witness's testimony relied upon by the SPO is, together with all of the evidence said to justify its admission under the relevant rule, in a witness package, coupled with the disclosure to the defence and the trial chamber as available material to challenge that witness, everything that could possibly be said to go to the witness's credibility. Now, I'm glad to know that will be done before trial. It's reassuring. It certainly means that you need to put a time limit on it. For example, end of January, if the trial chamber is to have liberty to begin a trial at any reasonable time next year. This is not a minor part of the prosecution's case. It's their answer to the fact that the indictment is overburdened. In other words, you remember there have been umpteen discussions during the pre-trial phase about shortening, slimlining the prosecution's case. They have absolutely refused to reduce the scope of the indictment to that which they need in order to in their view, focus on the accused, but instead insist on having evidence of every single allegation in the crime base, regardless of the fact that it has nothing to do with the accused, put into evidence. But in order to shorten their time limit, they've suggested that they will do this by the tendering of written evidence. Well, all well and good, but then do it properly and do it in a timely fashion, because otherwise we're going to have another series of delays at the trial chamber period that you have witnessed in the pre-trial period. And I'm sure the trial chamber will want to see the prosecution arriving once the case is transferred with its tackle in order, as would we, so that we can assist the trial chamber in reaching those decisions. We just take the point about the indications that Your Honour has requested and ordered for the defence to identify objections to admissibility, and on behalf of all defence teams, I think, it's been acknowledged that we can do that by reference to categories, but not by reference to witnesses within the time frame, because quite obviously we don't have this material. We don't have anything to fight at the moment because the prosecution is just bandying numbers, 154, 155 around. We need a properly reasoned case, and we would suggest absolute deadline should be the end of this year, 31st of December. And if it means that their Christmas holidays are a bit shorter, tough.
Thank you, Mr. Emerson. Mr. Halling, on the defense submissions, and especially on the suggestion to have a deadline that is earlier to the beginning of the trial for these materials to be provided.
Yes, Your Honor. The numbers that I am bandying around are the rules of procedure and evidence.
Correct.
And Mr. Emerson's preferences are not a substitute for the rules of procedure and evidence. There is no requirement in the rules of procedure and evidence for making a comprehensive summary of the kind requested. It is something within the discretion of the trial panel, and the trial panel may not agree with Mr. Emerson. They may prefer to have a more comprehensive receipt of the evidence instead of a summary in order to determine the truth properly. They may differentiate between witnesses. This is a matter for them to decide, including the question of deadlines as to when these applications will be filed. We have said we are going to file our first applications under these rules prior to the commencement of the trial. Just to be perfectly clear, the applications are, amongst other things, going to specify the exact ERNs of the statements being tendered for the witnesses and provide all supporting materials necessary to meet the procedural prerequisites of those rules. But there's no requirement as well that these applications need to be filed even before the commencement of the trial. These applications can be filed within whatever schedule the trial panel determines, and we think that this should be a matter for them to decide.
Thank you, Mr. Halling. Mr. Emerson, please.
Your Honour, the rule that Mr. Halling is referring to, the rules collectively all begin with a formulation that says, in slightly varying ways, the panel may admit the written statement of a witness or the transcript of evidence of a witness. Similarly, Rule 5.5, evidence in the form of a written statement or any other record or otherwise expressed of what a person has said or a transcript of a statement made by a person. They're references to something the prosecution identifies as part of its case to be put before the trial chamber. That cannot be done if you just give the trial chamber a list of ERNs of, as Mr. Kehoe said in one witness's case, 12 volumes of material. This is another dereliction of duty by this derelicting prosecution. They need to do their job, and that means they need to give the trial chamber a clear statement. It's perfectly clear from the wording of the language. It does not envisage a document dump. And how, in any event, could that be any use to the trial chamber? And why do we need a timetable? Because these guys can't be trusted in any way to be assistants to the trial chamber or the defence. They've been obstructive of the procedure all the way through. They've failed in their deadlines, they've failed in their duties, and as we've seen in closed session today, they have, in some instances, deliberately suppressed evidence. So we need to get on with this trial. These people have been in custody for a very long time for pre-trial period, and because the prosecution isn't taking a sensible approach to the scale of its case, they're going to be in custody for at least another 3 years while the trial is ongoing. It's no longer open to them to say we don't want a timetable, we don't want any rules imposed on us. They have clearly failed in the obligation to be professional prosecutors collectively and in some cases in this courtroom individually. And in those circumstances, a deadline is essential. They must clearly identify exactly which passages they are relying upon for any witness and reduce it into a single document explaining where it comes from. And the remainder of the material is fine for a document done, but how are we supposed to respond to an application under 155, which in their view will be made collectively by reference to ERN numbers? I mean, seriously, is this what they regard as a professional way to go about things? I mean, I do think with the greatest of respect, Your Honour should be calling time on this nonsense.
Thank you, Mr. Emerson. I don't see any request for the floor. So before we move to the transmission of the case to a trial panel, I note that several defense teams have made additional submissions. In its written submissions, the Thaci defense first requests a waiver for the framework. We already discussed about that. And I inform the Thaci defense that I will rule on this request within the context of the request for unique investigative opportunity, but I take note of it. The Thaci defense, supported by the Vesely defense, also requests an order requiring the SPO to systematically identify the portions of a lesser redacted document where redactions have been removed. The defense submit that one possible method of achieving this would be to highlight in a distinctive color the material which has been de-redacted. This proposal was raised inter partes with the SPO in the course of the Legal Workflow Forum, attended by representatives from each of the parties on 25 October 2022. However, the SPO indicated that they would not be prepared to undertake this exercise as it was beyond the scope of what they are required to do. So I first invite the SPO to indicate if this seems feasible or not, and when this could be done. Mr. Prosecutor.
Your Honors, briefly in relation to this last matter, it's not feasible. It would require quite a bit of work, in fact, because we would have to redo every single marked redacted version we'd filed in this case. I would also add, importantly, we're not obliged to do this, and it's not necessary to do this. The redaction codes from Your Honor's framework decision, particularly that E code for non-standard redactions, make clear what contents in the current redacted materials will be lifted. So where redactions will be lifted can be seen even now. There are also a variety of software tools which can be used to compare changes in two PDFs in the manner requested, though the technical modalities of this are a matter for the defense to resolve if this is something that they want. The defense is responsible for understanding the contents of the materials disclosed. It's not for the SPO to do their work for them. Unless there are any further questions on that, Your Honor, that's all we had on that point.
Thank you, Mr. Halling. Before I give the floor to the defense, let me ask the registry, do you think the registry could assist on this matter? Because if I understand correctly, I think there is a technical question, which is basically to have a software that allows a comparison between the two documents to identify what has been de-redacted. And there might be an IT solution to the defense requests. I mean, I guess you might not be able to answer on the spot, Mr. Nielsen, but at least do you think there is a room for discussions within the registry to see if you could assist the defense on this matter, at least to identify a technical solution?
Thank you, Your Honor. You're correct. I will not be able to answer it on my feet, but we're happy to look into it. Yeah. Thank you.
Thank you, Mr. Nielsen. Mr. Kihu, please.
Your Honor, we raised this because we were trying in an inter partes conversation to come up with a reasonable way to accommodate this. The first issue that we need to address is that it is not infrequent that we receive a document from the SPO to say this is an unredacted document without knowing what exactly has been lifted. Because the large items have been redacted in these documents, as Your Honor knows, and we just get little bits and pieces. It is not uncommon for us to go through that document all over again based on the SPO statement that this has been unredacted, and it hasn't been. So we go through hundreds of pages of information based on the statement of the SPO that this is now a statement in its unredacted form, and we have our staff going through them at the end of the day after all these hundreds of pages. It's the same document. And that has happened more than once to more than one of my colleagues going through this. Now, what we simply asked is, obviously they have somebody in there that in that redacted portion is inserting something where once it said redacted. All we're saying is just highlight it. That's all. That's the easiest way to do it. If there's someone who's going into this document and redacting it, what is the effort involved to either put it in yellow or put it in some other color of their choosing? That's all we ask for. It's to alleviate this administrative concern coming from, frankly, inaccurate information coming from the SPO where everybody's wasting time. Now, I would appropriate, if Mr. Nielsen has a solution to this, as he always does, Judge, you know, I go back with Mr. Nielsen for a long time. I know he'll come up with an apt solution. That'll be fine. That'll be fine. It's just something that would make easier all the way around for us to notify, to understand what's been changed.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, I would just like to highlight, if I may, I'd just like to highlight, if I may, one sentence from Mr. Holling's last submission. The defence is responsible for understanding the content of the materials disclosed. It's not for the SPO to do their work for them. It's the same attitude in relation to the Rule 155 and 156 material. It's the same attitude we hear over and over again. No matter that it may assist the defence to be trial ready, no matter that it may assist the interests of justice so that the trial chamber is approached by a defence and prosecution that are properly prepared and trial ready, no matter that it is in the interests of justice, indeed that seems to be a disadvantage from the prosecution's point of view, all that matters is whether there is an obligation expressly in the rules requiring them to do it. In any national jurisdiction, the object of the prosecution, as part of its duties, is to serve as an officer of the court and to investigate and present to the trial chamber not only evidence that it chooses to rely on, but evidence that may undermine its case. The role of a prosecutor in any civilized society nationally is to serve the interests of justice, not to serve the partisan interests of securing a conviction at any costs, however improper and however unethical. Always, 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 that is Mr. Holling's answer to everything, is we don't have to do it, we're not going to help the defence if we're not required to do so. And no thought is given to the fact that by obstructing the defence, and this is, let's be clear, obstruction, as with everything else, as with the 155, it's almost every time he rises to his feet, it's an answer in that character, and it's been the same in every hearing we've had. It's going to be Mr. Holling's motif, I suspect, as these proceedings continue, although hopefully he'll have the wisdom to rethink it before he reaches the trial chamber. But the aim of a prosecutor should be to prosecute fairly. This team has singularly, in every respect, failed to do that so far. It needs to stop and it needs to be placed under a discipline and a timetable to do its job fairly, not just in the interests of protecting, for example, Mr. Smith, as I get a request to go into private session just to keep Mr. Smith's name off the public transcript. It's not good stuff.
Thank you, Mr. Emerson. I don't see any request from the defense. Mr. Halling, do you want to add anything?
I think our submission on this point is clear, Your Honor.
Thank you, Mr. Halling. Let us move now to another request from the Thaci defense, also supported by the Vesely defense. In its written submissions, the Thaci defense indicated that the SPO adopted a practice of notifying some people they interviewed that they were present in the capacity of a suspect because there are grounds to believe that they had been involved in the commission of a crime within the jurisdiction of the case C. According to the defense, the SPO practice is prejudicial to the defense and has resulted in significant psychological pressure on those designated as suspects. The defense also submits that the SPO should be ordered to advise all those who are no longer under investigations that they are no longer suspects. So I invite the parties to provide their views on this issue, starting with the defense. Mr. Kihu, please.
Yes, Your Honor. Thank you very much. Your Honor summarized our position very succinctly. Obviously, there are scores, and I say that not exaggerating, scores of witnesses in Kosovo, former KLA members, who have been told that they are suspects by the SPO. Some haven't heard anything from the SPO in years, never been informed that they're no longer suspects, don't know what their status is, and of course, while we're doing our investigation, there is a fear and apprehension of those witnesses when we talk to them as to whether or not he or she is still a suspect. Obviously, we have the paragraph 35 where the SPO includes everybody in the KLA in this joint criminal enterprise. And that, frankly, Judge, has been supported by the scores of witnesses from the KLA in Kosovo who have been told by the SPO that they're suspects. And putting aside paragraph 35, those same individuals are very attuned to the recent statement by the SPO that the KLA is a secretive non-state actor behind its public face, and that they operate with a code of silence instilled over time. And this is the prosecution's submission of the revised witness list of 2 September 2022. So it's not just the description in paragraph 35 that we need not debate. It is this statement by the SPO approximately 2 months ago calling the KLA a secretive non-state actor who operates with a code of silence instilled over time. Now, parenthetically, look at a particular individual who 2 years ago, 3 years ago, was told by the SPO that he or she was a suspect and continues to be a suspect, and they live with this. There's no indication as to what's going on. There's no further contact. But you can envision, Your Honor, what that witness's response is when we sit down and attempt to talk to him or her about the particular events at issue in this case. Now, I'm aware of Rule 47 for individuals asking the court to terminate an investigation for a suspect, and I, as an officer of the court, I understand that I don't represent those individuals. However, there is an element of fairness and decency at this point to tell these people whether or not they are suspects. If they are no longer suspects, let them know so they can not only live their lives freely, but on our investigative level, enables us to talk to them without any fear on their part. If they happen to come here and they testify, certainly they can be cross-examined about anything he or she did. But to have this specter and this cloud over these witnesses for years, and it's been years, is simply dampening any ability to talk to these people for their fear of what they might come as a result of the SPO's conduct. And the easiest way for this to be resolved is to the SPO to come to Your Honor, and they can even do it, in camera, ex parte, and say, all of these individuals are no longer suspect. And then Your Honor can communicate it to us in due course, and then to the extent that we're dealing with these witnesses, we can let them know. There's no rule that is squarely on this, Judge. It's just a matter of decency and fairness. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honour, I would put the point slightly differently and perhaps take it a little further. It's obviously relevant when a witness comes to give evidence in these proceedings whether they are giving evidence under threat of prosecution. That is clearly a factor that may influence their testimony in order to exculpate themselves from any risk and may therefore undermine the reliability of what they have to say. With the sword of Damocles hanging over their head, that is a risk of distortion necessarily, which needs to be disclosed, explored, and taken into account by the trial chamber. That's the background to this. Any witness, and there are significant witnesses who the prosecution is proposing to call, but who was cautioned at the beginning of their interview that they were suspected of being guilty of a crime, we need, leaving aside what the witness needs, we need to know the basis on which they were suspected of a crime. So I'm going to ask for a ruling that with any witness that they propose to call, who they cautioned at the beginning of the interview, they provide the defence, first of all, with the reasonable grounds they had for suspecting that individual, properly articulated, at that time. Secondly, we will need to know, and this is, it certainly is covered by the rules because it's 103 material, whether the prosecution still holds that view and that they are still suspected of involvement in a crime when they testify. It's self-evident that this material always, in any criminal trial, is disclosable. If somebody is a suspect but cooperating with the prosecution, it's absolutely a fortiori that there be disclosure of the nature of the relationship in order that the defence can properly test it. So, first of all, what were the grounds for the reasonable suspicion announced at the beginning of the interview? Second, is that suspicion maintained? Because if it is, then there's a risk that it'll affect the witness's evidence. And thirdly, if it isn't maintained, what has changed? Those are the three things for every witness that was warned at the beginning of an interview, and that includes primarily, it's going to be relevant to the witnesses called to testify, but it's also relevant to the witnesses that they are proposing to adduce under Article 1, under Rule 155, etc. Because how can the trial chamber judge whether the witness is reliable without knowing if the prosecution, what were the basis for the prosecution saying they were suspected at the beginning of their interview, what the prosecution's position is now for the purposes of trial, and if something has changed between those two periods, on what basis has it changed. Those are all matters they are absolutely required by law to disclose under Rule 103. I would also say that if a witness is currently suspected, there's been no material change of circumstances that has altered the prosecution's position, or they're not able to point to one, then the witness obviously is at risk of prosecution. And that's extremely important because then they need two things. They need to be cautioned at the beginning of their testimony. They do not need to answer any questions if to do so would incriminate them. And they need to be separately legally advised. Those are the minimum requirements. I trust the prosecution has considered all this, and I'd like to hear their response.
Thank you, Mr. Emerson. Does one of the defence team wants to add anything on this topic? Mr. Young, please.
Yes, thank you, Your Honour. With great respect to the submissions made, we totally endorse them. That Mr. Keogh and Mr. Emerson raised very legitimate concerns, very serious concerns, which can impact hugely upon the lives of individuals, not knowing whether they are or are not a suspect, knowing whether they are or are not a witness indeed. That was something that was raised in previous status conferences. But to leave individuals in this way, when they've no doubt already taken a decision on dozens of individuals who are no longer suspects but still retain that status in their own mind, is is and may well be potentially prejudicial to the defence, because clearly it's going to impact upon the way these individuals may approach the defence teams if they are approached in relation to defence investigations. So it has may have a concrete prejudicial effect upon us as the defence. And Mr. Halling previously, in relation to the previous matter, was explaining how things were not feasible, there were no obligations on the prosecution, and he explained that the conduct that we asked them to, the route we asked them to go down was not in fact necessary. Mr. Kehoe mentioned, well, there may not be rules, but there has to be decent conduct and they have to behave as officers of the court. Well, in fact, there are some provisions which are relevant to this, and they come from this court's own code of conduct. And I'm referring to the code of conduct for the prosecutors and counsel. And in the version I have, under Article 6, Section 1, counsel, that includes prosecutors, shall, within their respective role in the proceedings, amongst other things, act in a manner compatible with fair trial principles and human rights standards, and under G, Article 6, 1G, maintain the highest standards of professional conduct in the preparation and presentation of a case. Take all reasonable steps to fulfil their obligations with the necessary knowledge and professional competency with respect to law and procedure. With respect, this is directly opposite to what we're talking about here. We're talking about modes of conduct by the prosecution which seems to fall below a threshold of decency, and it's also conduct that has a directly prejudicial effect upon us. It promotes a culture of fear, of ignorance, and it has a real impact upon us. So these are not theoretical questions that we're raising, they're very real issues, and I submit that the points made by Mr. Kehoe and Mr. Emerson are legitimate concerns that Your Honour should consider. Thank you.
Thank you, Mr. Young. Mr. Lagendra, please.
Your Honour, we too support the submissions that have been made by my learned friends before me. I don't intend to repeat what has been said, except that we also make the request for the rulings that Mr. Emerson has made.
Thank you, Mr. Lagendra. Mr. Emerson, very briefly.
Yes,
then,
I will be very brief, but just before the prosecution replies to this, I don't want there to be any misunderstanding, and for Mr. Halling to respond that it's no part of the defence's obligations to represent the witnesses. But that is absolutely clear. We're not here making submissions about the position of the witnesses or on their behalf. It's a pure fair trial question with Article 103 disclosure. This is material that is clearly the defence is entitled to as going to the witness's credibility and reliability. So it's a fair trial point primarily. And critically, additional to that, it's not us representing the interests of the accused. There is an obligation on the court to appoint and pay for independent legal representation for anybody the prosecution has not changed its mind about and won't give an undertaking to. Otherwise, you've got witnesses coming to give evidence, not knowing whether or not what they say may be used against them in a future prosecution. I mean, Mr. Krasniqi and Mr. Salimi were both prosecution witnesses in previous proceedings in the ICTY, and the next thing you know, they're in the dock here. And that's going to be the same for every one of the people they interviewed under caution. And it's self-evident that it may well have influenced the nature of the testimony, the account they gave in interview. But that, I'm not re-arguing any of that. The point is they have to be cautioned that they do not have to testify. And they have to be separately represented. Unless the prosecution has made a considered decision to reverse its original reasonable suspicion, and if it has, we need to know on what that suspicion was based and what has happened to change it. Those are minimum legal requirements of disclosure on the defence and their obligations on the trial court before the witness is called. And it's not a question of, I mean, I respect Mr. Kehoe's submissions and the submissions behind about compassion to the interests of the individuals. That's not our job. Our job is to ensure these trial proceedings are fair in the interests of our clients. And the problem they have is that they haven't addressed this question.
Thank you, Mr. Emerson. So now it's time for the SPO to address these questions. Mr. Halling, please.
Yes, Your Honor, and I'm going to suppress the instinct to comment on the interesting juxtaposition of some of the things Vasselli Defense's counsel has said today and a lecture about decency directed at us, but to focus on the agenda item at hand. A lot of the defense submissions on this point are stemming from a misconception that we are making a sort of subjective assessment when deciding whether people are suspects. Article 38.3 of the law obliges us to inform anyone it interviews that there are grounds to believe that they committed crimes within the KSC's jurisdiction. If that condition is met, we have to give the suspect advisory. It's an objective test. It's a statutory obligation. It's not a scare tactic. And truth be told, and contrary to what Mr. Keogh was saying in his original submissions on this, not everyone in the KLA that was interviewed got the suspect admonition. As Mr. Keogh and Mr. Emerson rightly recognized, and it's because it's true and inconsistent with their argument, suspects indeed have the right to contact the SPO under Rule 47 of the rules, should they wish to do so. But it's an entitlement of the person in question and not of the Thaci or the Vasselli defense on their behalf. In terms of the request for disclosure and Rule 103 content, this is another unsourced request presented by the Vasselli defense in this hearing with no notice, and we would ask again that this be done in writing. They set out whatever jurisprudential basis they have for a requirement like this, one that I've at least never heard of before at any other institution, and that we will respond accordingly to that request.
Thank you, Mr. Halling. Mr. Keogh, please.
Your Honor, it clearly is a tactic. These people have been told years ago that they are suspects. And I am not challenging that the admonition had to be given to the individual person at the appropriate time. I'm not questioning that. Maybe it did, maybe it didn't, but they gave that admonition. But it has been years since that admonition has been given. And these people still are under the specter of being a suspect. Without the SPO telling them that they're no longer a suspect. So we have the interesting situation where the SPO, based on their conduct in many cases years ago, is chilling the inclination of many of these witnesses, many. Scores, I emphasize scores of witnesses that have been told by the SPO that they are suspects, have chilled their inclination to sit down and talk about because they're afraid that the SPO is going to come back at them at some later date if, in fact, they testify for the defense in some way, shape, or form. Is it really too much to ask that many of these KLA soldiers and fighters who have been given this suspect classification years ago, is it too much to ask to tell them that they are no longer suspects? To free them of this specter? Put aside Rule 47. It's what the SPO should be doing. You shouldn't leave these people hanging out, on a tightrope for heaven knows how many years, simply because it fits their needs. No, this is not the way courts of justice should operate. I submit to you, Your Honor, these individuals, if they are no longer suspects in good faith, should be told. Thank you.
Thank you, Mr. Keogh. Mr. Emerson, please.
Your Honor, I think there's some clear blue water emerging between myself and Mr. Keogh. I am not associating myself with anything about what's in the interests of the witnesses themselves.
I understood that.
And in fact, the response of Mr. Halling is telling, because he rightly points out that some KLA witnesses were interviewed on the basis that they were suspects, and some were not. And those that were, as Mr. Halling rightly points out, had to be cautioned because they met an objective test, objective, the word being objective, test, imposed on the prosecution that if, on evaluation, there were grounds to suspect them of committing a crime within the jurisdiction of the court, they had to be cautioned. It wasn't some subjective endorsement of the prosecution. Quite right. quite right. Therefore, they must be able to articulate what those objective grounds were. That's a requirement of the law. If called upon to have sorted the sheep from the goats, they must have the criteria they used in a particular witness's case for deciding that he or she was on the suspect side, not the other side. And for Mr. Halling to say he's never heard in any other procedure of an obligation to disclose to the defence as relevant evidence, exculpatory potential evidence, that a witness is suspected of committing a crime, that is, I'm afraid, a sign of his relative inexperience, because it is an absolutely universal feature of every criminal justice system in the world that material going to an individual's credibility is disclosable by the prosecution to the defence. And it's in these proceedings embodied in Rule 103, which is binding on him. So I'm not quite sure whether it's wetness behind the ears or something more serious going on over there. But if they really don't realise that they've got an obligation to disclose those grounds to the defence, then there is a greater lack of legal expertise in the prosecution than I'd feared up until now. It's obvious. And if that's changed, we are obviously entitled to know what it was and why it's changed, because it's directly material to the charges against the accused on the indictment. There are key witnesses who give evidence for the prosecution about, for example, the organisation of the KLA General Staff. They were cautioned at the beginning of their interview, but they're no longer, it seems, suspected by the prosecution. They no longer meet the crime and the objective requirements of suspicion of having committed a crime within the jurisdiction of the tribunal, because presumably otherwise they'd be in the dock and not in the witness box. Or if a deal has been made that they should be a cooperating witness, that's disclosable. I mean, I don't know what on earth is going on that side of the courtroom, but this material is disclosable and it must be disclosed. And it must be disclosed now, as in before the trial begins, because it has a whole range of consequential implications on the instruction of lawyers to represent those individuals and advise them of their right not to testify. And all of that could derail the entire proceedings if it arises in the middle of a trial. Now, since it's beyond self-evident, even I hope, on reflection, perhaps he needs to read it up a little bit for Mr. Halling, that material is self-evidently disclosable and is required to be disclosed legally under the rules. I mean, I just don't understand how somebody who is speaking on behalf of a prosecution should say there's no rule. But it is, of course, yet again a reversion by Mr. Halling to the stock-in-phrase term. He doesn't even think whether there is an obligation. He just says there's no obligation in those terms in the rules, so the prosecution has to do nothing to ensure these proceedings are fair and just. I suggest again it's time for Mr. Halling to review his approach.
Thank you, Mr. Emerson. Mr. Halling, do you want to...
Just one point of clarification.
Twice,
my submission deals with KLA witnesses that are not only on the witness list, but the scores of witnesses that are not on the witness list that have been given the suspect admonition, of which there are, as I say, scores. So it's not just witnesses that the prosecutor intends to call. It is all of the others that we have been dealing with. Thank you.
Thank you, Mr. Kihu. Mr. Halling, please.
Very briefly, Your Honor, as Mr. Emerson decently said about me, the question is not whether someone is a suspect being disclosed, because the very premise of this question means that has already been communicated to the defense. Nor is this a question about deals being made, which is a distinguishable point. What we're talking about now is whether the SPO has to generate material explaining why someone is a suspect and whether it maintains its view that someone is a suspect just to disclose to the defense. And there is a need to litigate this in writing, as we said before, and we'll respond when that application is filed.
Thank you, Mr. Halling. I don't see any request for the floor. So we will now move to the Vesely defense concern in its written submission regarding reclassification of evidentiary material. The Vesely defense requests that the SPO be ordered to provide individualized explanations for the documents it seeks to classify as confidential. I note on this matter that the SPO made a filing yesterday following an order that I issued, I believe, in August, following a request from the Vesely defense. And in the SPO submissions, it provides a list of documents that can be reclassified as public. I will first give the floor to the defense if he wants to supplement, if the defense wants to supplement its written submissions, and then I'll give the floor to the SPO. Ms. O'Reilly.
Thank you, Your Honour. So just a quick update. This was filed obviously before we had that list of the documents that could be classified as public. There are some batches where it's relating to, two witnesses, and it's therefore possible to provide a generic description saying that, this is pursuant to a decision, etc., etc. But when it's hundreds of documents and you're just saying that it's being classified as confidential due to the context within which the information was obtained, the nature of the provider, and or potential identification of SPO witnesses, and or victims whose identity is not public, that's not sufficient. That doesn't tell us anything about the documents and why they have to be kept as confidential, because by virtue of the use of the phrase and or, the justification doesn't even necessarily apply to the documents in that batch. So that's the basis on which we're requesting more specific itemized explanations. And if it can't be done document by document, then it should at least be done as regards categories of documents. And we absolutely shouldn't have this and or formulation in the mix. Thank you very much.
Thank you, Ms. O'Reilly. Mr. Prosecutor, please.
Your Honor, we've already addressed, I think, a lot of the matters raised in the written submissions in our filing of yesterday. All that we would say for the moment is that our disclosure packages is the category of items for which we apply a classification, and whether or not the classifications we give are sufficient or whether reclassification is warranted is a matter for the trial panel.
Thank you, Mr. Prosecutor. I don't see any requests for the floor on this matter. Let us now move to the views of the parties on the transmission of the case to a trial panel and the necessity or not to schedule a status conference before the transmission. I know that the parties do not foresee any difficulty in transferring the case to a trial panel before the end of the year. However, the defense notes that prior to the transfer of the case, the SPO must have compelled all outstanding disclosure obligations and decisions on protective measures or challenges to materiality of documents that shall have been rendered. I also note that at this stage, the parties do not foresee the need for a further status conference before the transfer of the case to the trial panel. So I invite the parties to give their views on this matter, starting with the prosecution. Mr. Halling, please.
Yes, Your Honor, you summarized our position accurately on all of these points. The only thing that we were going to say is that there are multiple defense teams in their written submissions that talked about completing all outstanding disclosure obligations before the record is transferred. It's almost needless to say, there are certain disclosure obligations which, by necessity, we can't fulfill prior to transfer. The obligation to disclose lesser redacted versions of delayed disclosure witnesses 30 days before the trial commencement is another example. Rule 1023, which is a continuing obligation that will run throughout the trial, is another. That said, if the question is, can the SPO comply with all disclosure deadlines which it has prior to the record being transferred, we could say that we can, and up to now, we have.
Thank you, Mr. Prosecutor. Mr. Kehoe, please.
Well, I think it would be a bit much to say that they have met all those disclosure obligations. I notice you're smiling, Judge, because nobody can abide by that. Your Honor, we don't foresee any reason why it can't be transferred. Obviously, we have our unique investigative opportunities motion that can be carried to the new panel. Obviously, once again, I recognize that there will be disclosures ongoing, but for all of what we've been talking about today in the last status conference, et cetera, to get those items before Your Honor transfers the case sooner as opposed to later, that's what we ask for, but we don't anticipate any difficulty, Your Honor, transferring this case by the end of the year. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
There is one question which needs to be addressed, and that is the interplay between the issue that was discussed in closed session, the application that you suspend further consideration of the Rule 103 order, Rule 103 outstanding litigation in relation to Serbian intelligence manipulation, and whether your honour plans to deal with that before transfer, because that, of course, will have a significant impact on the prosecution's disclosure. They've steadfastly refused for 2 years to disclose this material. Clearly, if we win this litigation, they're going to have to do their disclosure exercise all over again. According to them, again, I think it was Mr. Halling, it's not possible and the rules don't require it. Well, if they turn out to be wrong about that, and every other trial chamber dealing with Yugoslavia has always said that is wrong, and that there is such an obligation, and the judgments make it very, very clear, but the prosecution has refused to voluntarily comply with that, that is something that is going to have a knock-on effect for disclosure. And I'm tempted, and I'm sure it might have crossed your honour's mind, to say, well, leave that all to the trial chamber. But that's Mr. Halling's response to everything, because he knows they can't complete their obligations within the legitimate time frame, so he's trying to suggest that everything should go off to the trial chamber. But that's not really the function of a pre-trial process. It's there to hand a case ready for trial over to the trial chamber. So I'm going to suggest that you want to provide a timetable for the exchange of pleadings on the questions that were raised in closed session, and an explanation from Mr. Teager and others of what on earth's been going on. And that you then rule on the Rule 103 issue before transferring the matter, so that the prosecution is in a position to make good Mr. Halling's claim that it's not practicable, so that when the case goes to the trial chamber, they know that the prosecution says, frankly, I find it extraordinary, and I don't really believe it, but prosecution has said that that would require a complete re-examination of their disclosure exercise, which they jolly well have to justify to the trial chamber.
I think you can imagine my follow-up question, Mr. Emerson.
Yes.
When will you be able to...
7 days.
7 days?
Yes.
Thank you very much. Ms.
And may I invite you to order the prosecution to respond within 7 days.
Thank you, Mr. Emerson. Mr. Young, please.
We have nothing to add, thank you.
Thank you, Mr. Young. Ms. Alagendra, please, or Mr. Bayezou.
We do not foresee any difficulty in transferring the case before the end of the year, nor to appear before the trial chamber after the judicial recess and the handover. For the status conference, we don't see the need to have one before the transfer of the case, unless there are substantive matters requiring an oral hearing. We suggest that any notification or updates can be submitted before the court in writing. And the last thing, we would like to support the request Mr. Emerson just made in relation to the outstanding Rule 103 material.
Thank you, Mr. Bayezou. Before I give the floor to the Victims' Counsel, Mr. Halling, can you just reply to the submissions by Mr. Emerson regarding the briefing schedule regarding the 103 application?
Your Honor, we certainly have no objection to Your Honor ruling on an application of this kind. Don't really understand why the briefing schedule needs to be condensed in order to do that, but we appreciate such matters are within the court's discretion.
Thank you, Mr. Halling.
And may I just respond to
briefly,
that?
please.
It needs to be truncated, because in order for Your Honour to rule on it before the matter is transferred to the trial chamber, as the rules require, because otherwise the prosecutor will then need to consider the implications for disclosure. So all of that needs to happen. And I'm going to suggest that until Your Honour has ruled on that issue, we can't decide whether a further status conference will be needed in December.
Thank you, Mr. Emerson. Mr. Laws, please.
Thank you, Ron. From our perspective, no difficulty at all in transferring this case to a trial panel before the end of the year. And again, just from our perspective, no need for a further status conference. Thank you.
Thank you, Mr. Laws. Mr. Nielsen, do you want to add anything for the registry?
Nothing from the registry. Thank you.
Thank you, Mr. Nielsen. At this point, I would like to ask the parties and participants whether they have any other issues they would like to raise. Mr. Prosecutor.
Nothing further, Your Honor.
Mr. Kihu, please.
Just one issue, Judge. Obviously, you saw that our pretrial brief has been filed timely. Obviously, the information that's in there was open source information or information that was provided by the SPO. We've seen all our docket numbers, ERN numbers, so that as a consequence, given those circumstances and given the lack of information that we have yet to get from the SPO, we will not be filing a 109C chart at this time. And I do believe there's a date on the 7th, on Monday, but we will not be filing a chart.
Thank you, Mr. Kihu. Mr. Emerson, please.
Nothing further.
Thank you, Mr. Emerson. Mr. Young, please.
Nothing further, thank you.
Thank you, Mr. Young. Mr. Lagendra, please.
Nothing further, Your Honor.
Thank you, Mr. Lagendra. Mr. Laws, please.
Nothing from us. Thank you, Your Honor.
Thank you, Mr. Laws. We will now break for approximately 25 minutes and we'll reconvene for a number of oral orders before we end this status conference. The hearing is adjourned.
All rise. All rise. Please be seated.
Before we conclude today's hearing, I will issue my first oral order related to Rule 1023 material requested by the defense after 20 May 2022. I order the SPO to finalize its processing of these requests by requesting protective measures, submitting materiality challenges, or disclosing all material not subject to protective measures requests or materiality challenges by 18 November 2022. This concludes my first oral order. I will issue my second oral order related to Rule 1023 material from the supplementary Rule 1023 notice. In light of the parties' submissions, I order the SPO to finalize its processing of these requests by requesting protective measures, submitting materiality challenges, or disclosing all material not subject to protective measures requests or materiality challenges by 13 January 2022. This concludes my second oral order. I will issue my third oral order on the disclosure of Rule 103 material. I order the SPO to review its supplemental Rule 1023 notice for exculpatory material and to disclose this material under Rule 103 or request protective measures for such material by 16 December 2022. This concludes my third oral order. I will issue my fourth oral order on the reclassification of evidence. Upon request from the Vesely defense, filing F00766, I had ordered the SPO to review non-confidential evidentiary material and to indicate, inter alia, which material can be reclassified as public at this stage. This was filing F00934. The SPO submitted that 8,076 non-confidential disclosed items can be reclassified as public, and that the remainder of the evidence must remain confidential so as to protect internal work products and provider restrictions, victims and witnesses to avoid prejudice to ongoing future investigations, and to safeguard the public interest or the rights of third parties. Having reviewed the Annex to F01079 as presented by the SPO, I am satisfied that the evidence can be reclassified as public. I hereby order the reclassification as public of the evidentiary items as set out in F01079-A01 and order the SPO to reflect this change of classification in legal workflow accordingly. The registry is invited to assist the SPO as needed. Relatedly, pursuant to Rule 82.5 of the rules, I order the registry to reclassify F01079-A01 and any translation thereof as public. This concludes my fourth oral order. I will issue my fifth oral order on the briefing schedule to supplement filing F00877-CORE. I hereby order the defense to file its supplemental submissions on Monday, 14 November 2022, the SPO to respond by Thursday, 24 November 2022, and the defense to reply, if any, by 29 November 2022. This concludes my 5th oral order. And finally, I will issue my 6th oral order. I order the SPO, when submitting its list for the first 40 witnesses to be called at trial, to indicate which part of the prior statements will be requested to be admitted under Rule 154. This concludes my 6th oral order. This concludes today's hearing, and will probably the last one before the transmission of the case, unless necessary. As usual, I thank the parties and participants for their attendance. I thank very much the interpreters, audiovisual technicians, stenographer, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.